You've spent a lifetime building something. Maybe it's a successful business, constructed from the ground up with long days and sleepless nights. Perhaps it's a portfolio of rental properties carefully acquired over many years to secure your family's future. You've worked hard, you've saved, you've planned. But then, the unexpected happens. A single, unfortunate accident on one of your properties, a contentious lawsuit from a disgruntled former business partner, a creditor claim that appears out of nowhere. Suddenly, everything you have tirelessly built feels vulnerable. The weight of that worry can be immense. It's a feeling many successful Canadians know all too well. In this video, we'll explore how Canadians can legally protect their assets using smart trust strategies. At its core, a trust is not a physical thing or a separate company. It is a legal relationship. Think of it as a formal agreement that involves 3 distinct roles. Understanding these 3 roles is the first and most crucial step. The entire structure is built on the interactions and duties of the people or entities filling these positions. This relationship allows for the separation of legal ownership from beneficial enjoyment. That separation can provide a layer of protection for the assets placed within the trust. It's a concept from centuries of common law, refined for modern financial and estate planning. The first role is the settlor. This is the person who creates the trust. The settlor is the original owner of the assets, be it cash, real estate, or shares in a company. To establish the trust, the settlor transfers legal ownership out of their name and into the trust's name. This transfer brings the trust into existence. The settlor also dictates the rules in a document called the trust deed. This document outlines how the trust will be managed, who will benefit from it, and under what conditions. The second role is the trustee. The trustee holds legal title and manages the trust assets under the deed. They have a fiduciary duty, the highest legal standard of care, to act solely in the beneficiary's best interests. Their duties include making investment decisions, distributing funds, filing tax returns, and keeping meticulous records. The final role is the beneficiaries, the people or entities intended to benefit from the trust. You might come across the term Asset Protection Trust, or APT. While often tied to offshore jurisdictions, it's critical to understand Canada does not have an Asset Protection Trust Act. Here, protection is achieved using traditional trusts under provincial trust law and federal tax law. You are not using a loophole. You are using a well-established legal framework for its intended purposes. Courts look past labels. Transfers must be genuine and complete, or a trust can be deemed a sham. A valid trust satisfies the 3 certainties: certainty of intention, certainty of subject matter, and certainty of objects. In Canada, the strategy is to use conventional trusts, like discretionary family trusts or alter ego trusts, to create legitimate separation. This requires careful drafting, an independent and diligent trustee, and operating the trust consistent with law. Professional legal and tax advice specific to your province is absolutely essential for success. It's a nuanced process relying on established doctrines, not an all-encompassing protection statute. There is a common and dangerous misconception that asset protection is about concealing wealth or deceiving creditors. This could not be further from the truth. Legitimate protection is proactive, transparent, and legally sound, minimizing exposure to future, unforeseen risks. Proper planning is done in peacetime when there are no existing claims. You don't wait for smoke and flames to buy fire insurance. You build the structure before any threat appears. Shielding uses established tools openly. Create the trust, properly record asset transfers, file all required tax returns. Hiding relies on secrecy and non-disclosure, and often illegality. Courts have little patience for it. By embracing transparency and planning proactively, you are using the rules as designed. Transfers made to defeat existing creditors can be reversed as fraudulent conveyances or transfers at undervalue. Asset protection through a trust is financial risk management, responsible, documented, and timely. One of the most common and flexible options is the discretionary family trust. Trustees decide which beneficiaries receive income or capital, how much and when. Because beneficiaries lack fixed entitlements, their personal creditors have difficulty claiming trust assets. Alter ego and joint partner trusts are available for Canadians aged 65 or older. An alter ego trust has one settlor who is sole lifetime beneficiary. A joint partner trust serves both spouses during their lifetimes. Assets can transfer on a tax-deferred basis and bypass probate, saving time and fees. While often used for estate planning, the change in legal ownership can add a layer of protection. Spousal trusts, usually created by will, provide for a surviving spouse while preserving children's inheritance. They can shield capital from potential claims and prevent diversion if the survivor remarries. The structure helps ensure the original testator's wishes are ultimately fulfilled. Each type has distinct rules and benefits. The right choice depends on your situation, age, family, and assets. Imagine Sarah, an Ontario entrepreneur who owns 100% of her profitable company. Her business faces risks like product liability and employee disputes. She also owns rentals that expose her to tenant lawsuits. On advice, she creates a discretionary family trust. Sarah is the settlor. Beneficiaries are her spouse and 2 children. She appoints herself and a financially savvy sibling as co-trustees. She transfers the company shares into the trust. Legally, the trust now owns them. Sarah remains CEO on salary. Profits flow as dividends to the trust and may be distributed tax efficiently. If she's sued personally for an unrelated event, those shares aren't her personal asset, making seizure harder. Protection isn't absolute. Timing and proper administration matter, or a court can disregard the trust. A trust is not an impenetrable fortress. Courts can look through illegitimate arrangements. If a trust is a sham or a mere alter ego of the settlor, judges will set it aside. Separation must be real in practice, not just on paper. In divorce or separation, courts can scrutinize trusts when dividing family property. They examine history of distributions and a spouse's control to assess value. Tax rules are strict. Most trusts face a 21-year deemed disposition that can trigger capital gains tax. Improper tax avoidance can lead to penalties, interest, even criminal charges. Trustee honesty, prudence, and loyalty are critical. A weak trustee can undermine the entire structure. Choose a trusted family member, a professional friend, or a corporate trustee for impartial expertise. Embarking on asset protection feels big, but it breaks into manageable steps. First, assess your situation: assets, risks, industry, personal guarantees, rentals, and professional liability. Second, assemble your professional team. Trust law varies by province. Get specialized legal and tax advice. Third, design the trust. Decide settlor, beneficiaries, assets to transfer, and the trustee. Draft a clear, tailored deed. Finally, implement and administer. Transfer titles. Keep separate accounts, detailed records, and file annual trust tax returns. Schedule regular reviews to keep your trust compliant and aligned with goals. Skipping professional advice is penny-wise and pound-foolish. This self-assessment and expert guidance form the foundation of a resilient structure. Effective asset protection in Canada is proactive structuring, not reactive hiding. The tools exist within Canadian trust law. Discretionary family trusts, alter ego or joint partner trusts, and other suitable structures. This is not about a secret loophole. It's legitimate, respected planning. Build a legal wall around assets long before any threat materializes. A trust works by separating personal ownership from the assets. A trustee holds property for your loved ones. That can place assets outside the immediate reach of potential future personal creditors. The process must be transparent, well-documented, and above all, timely. Courts dismantle last-minute transfers. The law protects honest, forward-thinking planning. Remember the roles, the Canadian legal landscape, and the real limits and rules that govern trusts. This article has laid the foundation. The key takeaway: start the conversation now. Next, we'll dive into how to set up and structure a trust for maximum legal protection.